Good morning, sir.
Good morning.
How are you?
Fine, thank you. Happy New Year.
Thank you. Same to you. And
Thank
is
you.
there any reason to go into a breakout room with the defendants?
No, I spoke with Mr. Marks yesterday via email. As soon as he jumps on, we were going to request a 2-week adjournment. I think most of the issues have been resolved. There's just one final issue.
Okay. All right. Thank you.
What should I say, Holly?
Ma'am, who just signed on? Good morning, ma'am. You're identified as Holly. Can you hear me?
It's for Rudy Smith.
Okay.
they're just out in the hallway. Oh, yeah, they did a great job, considering where we came from. I was calling for you because I turned it on. I was like, yeah, I don't know how he gets it to where it makes. Why are you watching me? I don't know how I feel about that. Yeah, yeah. Oh, good. I think we are. Oh, let me fix this. Here we are. This is 223088LT. This is Metro Commons versus Lloyd Evans Jr. and Jeannie Finley. May I have your appearances, please?
Good morning, David Morowski on behalf of Johnny Finley.
Good morning, Your Honor. Jeremy.
Lloyd Evans.
Plaintiff.
You're fine, Mr. Evans and Ms. Finley. I can see you and I know you're here. I note your appearances. Today is the day and time set for the Zoom bench trial. Mr. Morowski, I encountered Mr. Marks in the hallway and he indicated that this case would not be going forward this morning. The parties were looking for an adjournment.
Yes, I communicated with him yesterday. Most of the issues have been resolved except for one issue. And he had suggested a 2-week adjournment, to which I agreed.
2 weeks for the paperwork to be here in the court or 2 weeks for you to work it out with each other?
Well, I was just told a 2-week adjournment on the bench trial. There is no agreement. In a nutshell, Your Honor, there was a missing Sarah payment that was not applied to my client's ledger account. I had provided Mr. Marks information from Wayne Metro as to a direct deposit that had been made to a Comerica bank account, and his client was going to look into that. I assume if they can locate it and apply it to the account, that this would resolve the matter and the case would be dismissed unless there's an outstanding balance that is still owed. But beyond that, my understanding is the Sarah recertification check came in a few days ago and have been applied, and Mr. Evans and Ms. Finley made their good faith payment that had previously been agreed upon. So I believe once this missing payment is applied to the account, it should resolve the matter altogether. If it's not located on Metro Commons side and we have to go forward with the bench trial, I will have to produce a witness from Wayne Metro indicating that the payment had been made to an account provided by Metro Commons.
January 20th? It's a question, not a demand.
January 20th.
It's a Friday, 2 Fridays from now.
That's fine.
Mr. Morowski, 2 Fridays from now?
Yeah, yes, that's fine, Your Honor. And is this because I see Mr. Marks is in person and I did not know that, is the bench trial in person or is it via Zoom?
The adjourn date will be in person.
Okay, I apologize. I was not aware that it would be in person today.
No. He has another unrelated matter in
Oh,
person. You're
Okay,
supposed to be on Zoom. No, you're fine.
okay.
But the January 20th, 2023 trial will be in person. 20th, 2023. Is 9 a.m. okay with you, Mr. Marks?
Yes.
Mr. Morowski?
Yes, Your Honor.
Here in courtroom number 1 with me. Anything else on behalf of Metro Commons?
No, not this.
Anything else from Mr. Evans and Ms. Finley?
No, Your Honor. Thank you.
Thank you.
Actually, you know what, Your Honor, just to let the record reflect, even if this payment is to receive, and David, you can, this will be good information for you. There still will likely be a balance as January rent, as I can confirm, has not been paid yet. So there still will be issues likely, even if this payment is located. Ms. Everett, is making the good faith attempt to work with her colleagues in order to find it, but there might still be issues to move forward within 2 weeks.
Were you able to hear Mr. Marks just now?
I believe so. He basically
Okay.
stated that there will be a balance owing for January, which I'm assuming Ms. Finley can get from Metro Commons and make the payment in the next 2 weeks. And they're nodding their heads, so I assume they will take care of that.
I only muted them because they had background noise. But it's okay.
Yeah.
Anything else, Mr. Marks?
Not at all. That's it. Thank you.
Anything else on behalf of the defendants?
Nothing, Your Honor. Thank you.
Thank you. I'll see you in 2 weeks. Mr. Evans and Ms. Finley, have a good afternoon.
Thank you, Mr. Marks. Please be in contact. Thank you.
Thank you, David.
Any contact from Ms. Lacy? Or is she here?
I have not seen Ms. Lacy, Your Honor. Obviously, Mr. Smith is here. I don't know if we're on the record, but I sent.
We're on the record. We're streaming too, so just,
I guess we can, I don't have any.
okay,
I emailed her yesterday and not received a response.
thank you. Mr. Smith?
Yes.
Sir, you're supposed to be here in the courthouse.
What you mean in the courthouse? I'm supposed to be in person?
That's what live means, sir.
I don't remember. calling it.
The hearing is this morning, January 6th at 9 a.m. There is a live trial. The notice that was sent to you by our court staff on December 12th indicates in person at 11129 Wayne Road. This court is ready to, hold on. This court is
Okay,
ready to
sorry.
start the trial. It's scheduled at 9 o'clock. I call cases within 15 minutes of the scheduled start time. So I'm not sure what the status of the matter is, but I'm letting you know, if you have not already been in communication with your attorney regarding this morning's hearing, I would suggest that you mute yourself and figure out what the parties are doing. This court will be ready in 5 minutes to call the case.
Okay, thank you. Give me 1 second. Thank you.
Thank you, sir. So, you know, I'm silly, right? I'm silly. Greenfield Village. Yeah. I'm a huge fan of Abe Lincoln, and I don't remember that being there before, but I went last weekend. And they had a little plastic extrusion mold thing. So, yeah.
You know, when you buy a membership for there,
Mhm,
is that good for?
mhm,
So you go to ball.
mhm. And you get a couple extra passes. I'm always getting them, because I've kept my membership for years now.
Yeah.
I always go by and see the chair from the Ford Theater. I always go sit on the bus and look at the presidential windows and stuff like that. I went by myself. My husband was otherwise distracted. I wanted to go because they have those Disney
Oh, yeah.
live action costumes.
Your Honor?
Sir.
I didn't mean to interrupt you.
I
If
can
you're
talk to
calling
Brooks
5 minutes,
whenever.
Do you mind if I step outside my client? I mean, if you want me to
Absolutely.
take
No, I'm
testimony-
leaving. If you
I was just gonna, if we're gonna take testimony and.
Okay.
and I'd like to talk to her.
you don't have to do it in the hallway. He can put you in the room so you can have a
Okay.
little privacy if you
Is that
like.
okay for a few minutes?
Absolutely.
Okay.
Man. Was that? I think last week, last Monday, last Tuesday. Oh, was it? I think so. I saw them out the corner of my eye when I was looking at Morowski, and I saw that there had been some petals that fell. Uh-oh. Is she here? I'm ready for them, yes. I guess not.
Just these.
I'm ready. What kind of? Officer Brooks, I'm only responsible for myself Monday through Friday, 8 to 4. I have no idea. We schedule, that's all I can do. I say it out loud on the record. I repeat it one more time. Mary Ann or staff downstairs sends out notice. We invite you to the party. If you don't want to come, I understand, but we're doing it.
Yeah, she went to the library, and then I think she started walking towards. Sustenance.
Mr. Marks, I have nothing but patience. There's only 3 cases scheduled today. I'm not usually impatient, except around lunchtime. I'm looking at the stars.
Regardless,
Well, that's not my problem anymore. There's somebody else to tend to her and her nonsense. I'm sorry, sir, what did you say?
I just said regardless, I'm appreciative.
Thank you. Yeah, I spent, 22 years sitting waiting for people to come out. So I'm always like, I'm here, I'm ready when you all are. This is 223384 LT. This is Park Estates versus Rudy Smith.
Jeremy Marks appearing on behalf of the plaintiff, Your Honor, as Miss Lacy, is she appearing? Oh, okay. She filed an appearance in this case, and I've been working with her just as you know, as full disclosure, but I'm not sure if she's here or not.
Mr. Smith?
Okay, I'm gonna let her know now. Bye.
No, what did you say, sir?
Oh, hello, can you hear me?
I can hear you. I just
Oh,
couldn't hear what
sorry.
you just said.
I was talking to the lawyer. She said she's finna pull over right now, and if it's okay with you, she can log into Zoom.
Today is the day and time set for the in-person trial that was scheduled the first hearing in this case was back on August 17th, 2022. We are now almost 4 months later. Case has been adjourned multiple times for multiple reasons.
Your Honor, I just would like to, full disclosure to the court, the notice to appear does say pretrial conference, but does say in person. I wrote down in my notes it was a bench trial, so that's why.
Why are they calling it pretrial? Thank you, Mr. Marks. Because the notes in the file indicate from 12/12/2022 that we were adjourning hearing. And under that, I wrote trial live, January 6, 2023 at 9 a.m. in courtroom number 1. And you are accurate. The notice does say pretrial at the address above. At the end of the day, Mr. Smith has been logged on for probably 20 minutes at least, maybe a little longer. And whether we were Zoom or live, Miss Lacy is not here. I'm here until 4 o'clock. I'm happy to wait as long as you're willing to wait for her to log on or to appear in court. What's your pleasure, sir?
I'd be okay with Miss Lacy. I'd be happy with Miss Lacy logging in.
Here she is. Good morning, Miss Lacy.
Good morning, Your Honor. I do apologize. I was en route to the court, and I got the call from Mr. Taylor.
Mr. Smith,
Mr. Smith, I'm sorry. Is Mr. Marks present, Your Honor?
he is live here. That's him
So
sitting at the desk.
I can be there in 10 minutes. I did get a chance to finally talk to Mr. Smith. We've been trying to get in, well, I have been trying to get in touch with him for the past 2 weeks, so over the whole break, after we had already agreed to the conditional dismissal with Mr. Marks just to confirm the dismissal. And I was unable to get in touch with him. And I see his number has changed since he called me today. So I did want to speak with Mr. Marks regarding the conditional dismissal. If that's possible, and I hate to waste the court's time, but Mr. Smith has one question, so I need to clear it with Mr. Marks.
Miss Lacy is not a waste of my time. I'm here Monday through Friday, 8 to 4.
Well, I just
So
apologize
if you
for
need
the,
to, no, I appreciate that, ma'am. My concern is that this case was scheduled to be live at 9 o'clock and is now 9:30. And your client is on Zoom, which is, I know not what we agreed to and what was stated and what
Right.
appears on the notice. So have you resolved your question with Mr. Smith? Or do you still need to speak to him before you speak to Mr. Marks?
nope, I resolved my question with Mr. Smith. I just need to speak with Mr. Marks real quick.
He's here in the courtroom. Do you need to
Yeah.
speak to him privately?
It's not necessarily, it's just pertaining to the agreement, Mr. Marks. Mr. Smith, and like I said, I would have had all of this before if I could have contacted Mr. Smith. He wants to know if he can do half of the agreement this month and half of the agreement next month by the 15th, and including the rent that is due for each month, if that's agreeable to you and your client.
I don't feel comfortable talking about this on the record.
Then
Okay.
what we'll do,
I mean, if Miss Lacy can be here in 10 minutes, I'd be happy.
Yep,
I'm assuming-
Yep, I can.
did you say 10? I thought you said 2. Is it 10 minutes that you're away?
10 minutes, I just pulled off of 94. And again, I apologize to the court. I am raising kids and parents. Both of my parents had debilitating strokes, and they were just sent here to Michigan a couple weeks ago. So I'm still trying to juggle that. And so I do apologize for the late get out the door. But yeah, I can be
Miss
there
Lacy?
in 10 minutes.
No worries. And, we all have life in abundance sometimes. So what we'll do is this court will be in recess. Mr. Marks is here with his client. They'll go back out into a conference room. When you are here and you and Mr. Marks are ready, will let Officer Brooks know. He'll come get me. I'm here. I'm not going
Okay.
anywhere. Okay.
I appreciate
Thank
that, Your
you.
Honor. I'll be there shortly.
Thank you.
Thank you for your patience, sir.
Thank you.
No, on my phone. Just stayed in there in the room or something. That's fun. Well, I just trying to get people tickets. So if you look, like first of all, let's see. Unless you grab a bunch of stuff. This is the end of it. Sound like on it.
Yeah.
Just take it and go somewhere else with it, right?
That's right.
Yeah.
Yeah, you should be present. Because the judge is about to come back down. Did I send it to a different email? I was just looking for it before I sent it. Oh, so you don't even know. So I'm trying to find. So you can send it to. I'm getting some, but I wasn't.
I still think that's it.
Yeah, some are coming in, some aren't. Probably. I'm sorry.
It's a reflex at this point.
I know. He does it all the time and I wave him down. This is too unbelievable. There's only 3 files and of course I grabbed the wrong one. So yeah, it's your races. This is 223384 LT. This is Park Estates versus Rudy Smith. May I have your appearances, please?
Good morning, Your Honor. Jeremy Marks appearing on behalf of the plaintiff.
Gabriel Lacey appearing on behalf of Mr. Smith. Thank you. And Mr. Smith appears on Zoom. Today is the day and time set for the trial in this matter. Well, I said that, but Mr. Marks pointed out to me earlier that the notice that was sent out to the parties indicates pretrial. Mr. Marks, how are we proceeding this morning?
Your Honor, we had an opportunity to speak with Ms. Lacy prior to this hearing. We agreed to terms for a conditional dismissal. I'd be happy to place the terms on the record and then after this hearing, circulate the document for signatures and submission.
Thank you, sir.
Let me get the, sorry, I'm gonna get the current balance. There's a current rent to retain of $7,087.97. That might have been altered as of today pursuant to the lease for a late fee perhaps, but give or take around that number. That was as of yesterday. Also, court costs will be added to this case as well at $153.57. There has been an agreement reached where Mr. Smith will be paying $3,500 on January 15th, 2023, and then the remaining balance by January 31st, 2023. There will be a clause within the conditional dismissal that all additional fees and costs pursuant to the lease that accrue will be also due. So basically an entire pay in full by the 31st with an initial payment by the 15th. But I'll verbalize it better in the conditional dismissal.
Anything else?
That'll be it, Your Honor.
Any additions, corrections, deletions?
No, Your Honor, that is.
Thank you. Mr. Smith, were you able to hear the attorneys just now?
Yes, yes.
How long do you anticipate to need to prepare the conditional dismissal and circulate it to Ms. Lacy?
I'm going to draft it. I'm going to draft it this weekend and give it to my client for final review.
You're not drafting anything this
I will
weekend?
be, Your Honor. Yeah. Very busy, but I will do it forthwith as fast as I can. I want to get this done for my client. This has been going on for quite some time. I will get it to my client for final approval and then send it to Ms. Lacy.
And I will review it. I've already agreed to review it over the weekend. And we'll have it.
I don't know if you'll get it by the weekend, but I'll.
Okay. I'll review it as soon as I get it.
What I will do, you say this weekend, and we'll say a couple of days. What I will do is schedule a live bench trial, live in person here at 34th District Court, physically in the building, January 20th, 2023 at 10 a.m. I don't anticipate that we will actually see you in 2 weeks, Ms. Lacy. If Mr. Marks gets that out to you by Wednesday of next week, by the time you circulate it, get your client sign off on it, have it back here, I would think that we'd have it at least a couple of days before. If there is a small sticking point and you just need a little bit more time, please reach out to Mary Ann or submit an email to Civil Department and let them know. I do adjourn dates versus putting it on the no progress docket because attorneys don't take the no progress docket seriously. I never did. So just get the conditional dismissal signed and get it back and we'll consider this matter resolved. Anything else, Mr. Marks?
Not this time, Your Honor. Thank you.
Anything else, Ms. Lacy?
Not at this time, Your Honor. Thank you very much.
Thank you, ma'am. You both have a good day.
Thank
It's-
you.
Happy New Year. Mr. Smith, you're free to go.
Thank you.
Nobody here for a 10 o'clock? Oh. Well, it's supposed to be on Zoom, but you never know. Mr. Morosky, have you been in contact with someone from Palace office?
Yes, we exchanged emails yesterday. I would like to speak to Ian Morton when he arrives.
Okay, what we'll do is, when his office logs on, Mary Ann will get you into a breakout room, and when you all are ready, somebody will let me know. Thank you, sir.
Thank you.
So this one is gonna be
This one is Zoom for real.
Okay. You're welcome.
Good morning, Mr. Morton. How are you?
Morning. Can David and I go into a breakout room?
You bet. I'll do that right now.
Thank you.
Madam Clerk, my client has not arrived yet.
I'm sorry, Mr. Morowski. Did you ask me a question? You're muted.
Yeah, I was just looking for my client when she arrives. I've been trying to reach her. I need to speak to her in the breakout room.
Okay, you got it.
Thank you.
You're welcome.
Madam Clerk? Can Ian and I be put in a breakout room?
Are you ready for the judge?
No, I need to speak to Mr. Martin again.
Okay.
Thank you.
Yep, you're welcome.
Mary Ann, can I go back in the breakout room with my client? And I think we'll be done.
Did you need to go back and speak with your client?
Yeah, and then I think we'll be done after I talk to them.
Okay,
Thank you.
you're welcome. All set?
Well, it looks like she dropped out of the bakery room. I don't know if it was a issue
Oh, okay,
on her end or she left.
okay. When she comes back, are you ready?
Can I talk to Ian one more time? I'm sorry.
Yep, that's okay. He sounds.
I'm about to unbunch and gone. I'm about to punch out. I'm not gonna. Shit I got to do. I got shit I got to do. I be waiting on. I have this my schedule around you. Then when you be doing when weird shit be going on, you think I'm supposed to be keeping my shit on hold. I don't have time to be keeping my shit on hold. Now, I'm not getting mad or nothing. I'm just saying if you're finna punch out so I can take you home so I can start my day before I go to work. That's all I'm saying. I'm gonna have to call him and tell him I can't get my kids today because I got shit going on. I got personal shit going on. It's shit that I have to start getting done. I was supposed to get my kids today.
Oh, she's back. Okay. Miss Lee, I guess then, Marianne, if I could talk to Miss Lee one more time, it will be very brief.
Are you all set?
If I could speak to Miss Lee just one more time in a breakout room, will be
Wait,
very,
the judge is coming out right now.
okay.
This is 224651 LT Rawsonville Woods versus Crystal Lee. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Rawsonville, P67892.
Good morning, Your Honor. David Morosky on behalf of Ms. Lee, 57261.
Thank you. Good morning. Today is the day and time set for hearing on the adjourned request for entry of execution, order of eviction. Mr. Morton, how are we proceeding this morning?
Your Honor, at this time, the parties have not been able to reach a resolution in this case. Was that there's been ongoing negotiations and settlements. I'm not going to share negotiations and discussions, but what I will say, Your Honor, is was it an alternative to asking for the writ to be entered today? What we would present to the court is if the order of eviction could be stayed until the 31st, along with the release of escrow of the $1,272 to my client, which would give Ms. Lee an opportunity to be able to vacate, as well as the release of those escrow funds to my client. And this is a possession-only action, so any other remaining disagreements the parties might have when it comes to the balances could be dealt with at a later time, because again, this is a possession-only action.
Your Honor, David Morosky for the defendant, Ms. Lee. Ms. Lee is the one who filed the motion, and I'll let her speak as to the additional basis as to what I'm going to state. Part of the issue was with respect to what Ms. Lee was contesting with the judgment was that she had received SARA funds and she did not believe they were properly applied to her account before the judgment entered. Additionally, Ms. Lee is stating that she made a payment in August. I've talked to Mr. Morton as to the SARA funds, and there should have been $75 in late fees that should not have been charged to the account. They should have been waived. And I believe Mr. Morton is willing to waive those amounts. As to the August payment that Ms. Lee states she made, I will let her speak to that effect because I as an officer of the court, I can't advance that argument because I did not file the motion. And I know it's her testimony that she can provide, but basically that was the basis for her motion in staying the writ, because she had believed that the amount was not proper on the judgment. Ms. Lee?
Wait, before she starts talking,
Sure.
am I understanding that you all have been in and out of the breakout room for an hour and we're down to $575 from August?
I'm not sure where the $500 came from, Your Honor, but I'm just referencing the $75. I did not get the ledger from Mr. Morton until yesterday, and that's why I was not able to talk to my client about it until recently. And the issue is that she's disputing the amount of the judgment. Without going into further discussion between what we've been talking about in the breakout rooms, Your Honor, that's the only defense that I could advance at this time for her motion.
That the balance listed in the judgment is incorrect. That's the argument.
Yes, I believe so.
Okay, the $575 comes from the complaint, which lists the monthly rent at $575. And if the issue is August, I'm sorry, I'll stop for 1 second. You were trying to have Ms. Lee provide some information.
Yes, Ms. Lee, you were telling me that you do not believe your account was credited for a payment in August. Is that correct?
Yes.
Do you know the amount that you paid to Rawsonville?
I don't have the exact amount in front of me because I'm at work, but it was the base rent and the home rent too. So it was
And your base
roughly
rent,
around 12 something.
your base rent, and I apologize, is $575, correct?
Correct.
And your home rent is $594.
Correct. Plus the other fees, the shed and the animal.
And the shed fee is $50, and the pet fee is $50.
Yeah. So it's roughly about like 12, usually about 12 something a month,
Okay.
give or take.
You know how you, did you, do you know how you made that payment? Was it through money order?
No, it was through the resident portal.
And you do not believe that was credited to your account?
Correct. And it was, I believe it was like August 31st, if I'm staying correct. I don't have it in front of me. I apologize, I'm at work.
Okay. It's my understanding that was the basis for you challenging the judgment. Is that correct?
I'm sorry, repeat that.
Is it my understanding that was the basis for your motion in challenging the judgment?
Correct.
Your Honor, basically, if you know, if the account could be, or the judgment be amended to reflect the payments less, and also the $75 that should have been waived through the Sarah payments, basically, with what Mr. Morton is proposing, with the writ date not to be executed on or before January 31st, I believe, you know, that is what Ms. Lee would be asking for unless she objects. Ms. Lee,
I'm sorry, what was that?
you're asking the court to amend the judgment amount to reflect that payment?
Yes.
Okay. And Mr.
Wait,
Moore-
I'm sorry. Mr. Morton, is that something you're agreeing to?
Your Honor, was it what, I mean, look, was it, I feel like, was it, what I'm proposing then, Your Honor, is look, all payments that have been received have been applied. What I'm proposing then, Your Honor, is the fact is that we can enter into an amended consent judgment with, and that the writ cannot be ordered till after the 31st. We can change this to a possession only action. Because was it where it's, she vacates or we go get the writ, because this is filed as a possession only action. So that way, all the amounts are removed, so there's no more confusion in regards to that. However, in consideration of extending it out to the 31st, we would ask that the escrow be released to my client. Then again, she vacates, she's going to be issued a damages statement, which will break down all the amounts, because right now, there's over, you know, we allege right now, there's over $8,500 due, because it's been a long time since payments been made.
Wait,
you know-
no. I'm stopping you for a second because
Okay.
clearly there's something else. Where I am and what the court sees in the file is a judgment by default from October 27 that says pay or move, pay $3,155.04 or move by November 7.
Yes,
The court then received a motion. I'm sorry, the court received the application and order for eviction, which was signed on November 28th. Ms. Lee came and filed with the court a motion to quash the writ on November 30th, alleging that the balance was wrong, didn't attach anything. The court scheduled the matter for hearing. The parties appeared on December 12th. Escrow was established. No one ever sent in an order for escrow, which caused whatever issues downstairs. And we adjourned the hearing to today. Today is proofs that the amount claimed due, today is proofs that the amount claimed due in the judgment is improper and that plaintiff's writ should be quashed or immediate execution of the writ. And the two of you are talking about something completely different.
that is correct.
Mr. Moore, am I misunderstanding the status of the case?
No, Your Honor, I think it's because we've been, as the court's made aware, clearly aware, we've been going back and forth for over an hour now, trying to resolve something potentially. And we're still trying to give an opportunity to be able to avoid the immediate writ with the release of the escrow, to be able to give more of an opportunity.
And
But it's
your,
not fair.
and Your Honor, I apologize. One of the other things that came up at the last hearing is that the ledger that Mr. Morton had previously provided to me had only gone back to September. So I had asked that he provide me a ledger going back to show that the Sarah payment had been applied. So we could address those proofs and see whether or not they were necessary. And unfortunately, I didn't get that till yesterday. I'm not trying to put any blame on anyone. But that's why we've had to discuss this today in court, Your Honor, and that's why it's taken so long. I think. I'm sorry, Ms. Lee.
It's not fair, you know, it's not.
Well,
I
Ms. Lee. Okay. Ms. Lee was talking to me, Your Honor. She's explaining that she had difficulty opening the ledger that I'd sent to her after I received from Mr. Morton. I apologize. But basically, if Mr. Morton is telling me that this will be a judgment for possession only with no amount listed on it, I think what he's proposing is that the judgment be amended accordingly with a new writ date of January 31st. And Ms. Lee, what he's saying is basically that the judgment would not state a dollar amount owed. It would just require that you have to move out by January 31st. So it wouldn't list any amount entered against you.
But if the judgment is for $3,000 or something, why can't I just pay that? I don't understand.
Your Honor, may I address my client?
Can you what, sir?
Address my client as that issue.
Absolutely.
Ms. Lee, the time to pay on that amount has long since passed, unfortunately, unless we enter into a new judgment amount today. And at that time, I'm assuming Mr. Morton is going to ask for November, December, and January's rent be added onto that.
That is correct.
Well, December has already been paid. So, and I can pay January, so why can't I just pay the $3,000 and then pay January?
Your Honor, I don't know where to go with this at this point with my client in open court. I don't want to, you know. I guess I would just say, Ms. Lee, even if the amount is reduced, the judgment would enter in full for today, which I'm assuming the judge would give you 10 days to pay or move out. So without reciting settlement negotiations on the record, I believe what Mr. Morton is proposing is fair and reasonable in that no amount is owed. You'd just be given extended time, more than 10 days to vacate. But I'll leave it at that, Your Honor.
If I may, Your Honor, I would say, was it the plaintiff's proposing either one, that the resolution I proposed, which is allowing her to 31st to be able to vacate, to give her the opportunity with the release of escrow to my client, along with the amended possession judgment, or alternatively, Your Honor, you know, we'd ask that the writ be entered. But I mean, I'm proposing the first one first based off of, you know, communications and you know, and continuing to have good relationships with councils and with the court. So.
Mr. Morton, I appreciate that, but the thing is, I don't want to get into your negotiations. That's beyond the scope of what we're here for this morning. Amending the judgment is something that you two decide on. The only thing before me this morning is ruling on the motion to quash. And there's been nothing presented to this court that shows that the previously entered judgment from October, whatever, that amount was inaccurate. The motion that was filed, the court would have allowed time for Ms. Lee or her representative to present proof that the October 27th, the amount on the October 27th judgment was in error. She alleged it in her motion, didn't attach anything. We were here on the 12th of December, didn't attach or provide anything. Comes this morning, doesn't have a screenshot, any exact date of payment. She says she paid it through the portal. If you paid it through the portal, the money is still coming from somewhere. So the court is not inclined to quash the motion, to quash the execution that was signed November 28th. So it's this, if the attorneys agree to proceed a certain way, the court is happy to proceed that way. But my inclination at this time is what's before me is only as to the order of eviction.
Understood, Your Honor. So I'd say unless Mr. Morawski agrees to the terms that I presented as the option one, we'd ask that the order of eviction be allowed to proceed then. So I'd leave it to Mr. Morawski at this point.
Your Honor, if I may just talk to Miss Lee one final time. She had dropped off the breakout room before you came onto the record, and I was asking me, and she had reconnected via Zoom, and I was going to talk to her about that very issue before Your Honor took the bench.
She- you can go back into the breakout room. I had Mary Ann bring you out now because she can't leave her desk. She's tethered to her desk monitoring Zoom so that I don't miss you all, but she'll send you back into a breakout room right now.
Yeah.
Thank you, Your Honor. I do apologize.
Don't apologize, sir. Just don't want to hold up anybody's day. Mary Ann will get you where you need to be. And as soon as
Thank
you're
you.
ready, she'll have me come back out.
Thank you.
Over there by Washington and apply. Across from Washington Community College. They seemed like they were pretty and over and by La Forge. Some places that seemed like they were okay. Hold on, they did punch. Can't look yet. It's just sound like we're gonna have to go.
And tell him they can get their money.
So you started to say earlier today, something about chair races?
Remember, I brought that up before the December Christmas holiday break,
Yep.
and so I mentioned it to Kid, and he says somebody will get hurt. Well, that's life. Then you'll have an interesting scar that you can tell people about. But I see all those chairs in the Sally Port, and I think to myself, they can zhuzh them up with a little bit of tape and racing fire stripes and everything else, and
I
fake
think that
engine noises.
That would be fun.
It's a Friday after. No, it's a Friday afternoon. Nobody will be here.
And you do it in the Sally Port?
No, well, oh, you know what? They could do it in Sallyport because there's only, I think the space is empty. If they race from the back of the Sallyport from the east wall to the west wall, I was thinking they could do it in the front lobby around where the carpeted area is, just one lap around. And the winner gets the belt, which means I'll have to find a very decorative belt for them to wear or a little trophy or something.
That would be funny. That's a visual.
Well, now that you say the Sallyport, that might actually be better. We can bring sidewalk chalk in and make racing lanes.
We have to get the padding that they have at the gyms in case someone wipes out.
Your Honor,
Sir,
may I speak to Mr. Morton one last time, please?
absolutely.
Thank you.
You can go back into 3 where you were before. Oh, no, he went into 1. Oh, Mary Ann, I don't care where they go. He went into 3.
Okay, so I'm going into 3.
Would you please?
Okay,
Thank you. Well, Mary Ann, we still had that blue padding
What blue padding?
from the elevator.
Oh.
If they're concerned about falls, we have safety equipment available.
We need to talk to someone.
It's a team building activity.
Yeah.
Did you look at next Wednesday yet?
I did, and it's not so bad. It's I have 6 pages. Wait a second. Oh, that's right. We have the exam. So it's really 5 pages.
Really? Okay.
Yeah, but I printed that off yesterday, so it may have changed.
I ran into probation this morning and she was bringing the files up later. I think they're short staffed today. So Ms. Rapp was still working on the files for Monday.
We just have a couple for Monday.
And then nothing on Tuesday.
Right. And then what's our, let me see. So we have Wednesday and Friday.
And then Friday.
Yeah.
Friday, we have the final settlement conference on one of our February jury trials.
You know, when you set that jury trial, or no, the bench trial. Let me see. Oh, Daryl Floyd, okay. We had that jury trial for Daryl Floyd, but that motion got adjourned to April. I was like, what's going on?
What motion got adjourned to April?
We had that. Daryl Floyd. Jury trial, and on my calendar, I have adjourned motion to 4/13.
I'll have to look at your calendar because that date's not ringing a bell.
Okay.
April 13th. Oh, that's a Huron Day.
Yeah.
Hmm. I don't know. Never a dull moment.
Yeah, I just pulled it up. It was, yeah, that jury trial, that's the one that went down, and then the motion's not until April.
I don't think that's labeled right. I don't think it should be.
Did you pull it up?
I'm just looking at I was just looking at the calendar. I'll look at the ROA in a moment. Oh, I'm thinking about two different things. Okay.
It just,
Yes, it was. It clicked in my head why it was scheduled the way it was scheduled. I was thinking about. Oh, because that's off. It was removed from 120. It's still on my calendar for 120, but it's not on the calendar for 120.
oh, okay.
It's moved out to allow time for different things to happen outside of the courthouse. I was thinking about a completely different case. But yeah, that thing. Let's look here and make sure. But since they're still in the breakout, I'm coming back to you for a second.
Okay.
Mary Ann, can I go back in with Miss Lee very quickly?
Sure. Miss Lee?
I believe we have a resolution. As soon as my client comes out. Ian, is this being done via what instrument?
I'm sorry, go ahead. What were you gonna say?
Is it amended? Or are we gonna do a?
I could do an amended consent judgment and I can prepare that and send that to you today. Would you like me to put the terms?
Yes.
Okay. So the terms are as follows, Your Honor. The parties will enter into an amended consent judgment today. The balance due is $8,346.60. The escrow that is in holding with the court right now of $1,272 shall be released immediately to the plaintiff. Further, the defendant shall pay $5,000 on or before January 31st, 2023. At that time, Your Honor, there will be a remaining balance of $2,074.60, which will be paid in two separate increments of, was it at the end of the fall of February and March, as well as the defendant shall be responsible to pay ongoing rent as it accrues during the term of this consent judgment amount.
And just for the record, Ian, that would be starting February 1st.
Correct.
Right. Okay.
That is correct.
Ms. Lee, is that accurate as to what we've agreed upon?
Yes.
Okay. Okay. And then
And
upon,
Miss,
I'm sorry, Your Honor. I was just going
I'm
to say,
sorry, you go ahead.
upon payment of full, Mr. Morton will file a satisfaction of judgment, so there will be nothing on the client's credit history with respect to that, correct?
No issues whatsoever. No objection.
Thank you.
And Mr. Morton, you indicated you'd be drafting that document today.
Yes, I'll be drafting it and then sending it over to Attorney Morosky today.
There's only one thing, and it can be resolved one of two ways. There is already a signed order of eviction in the file signed November 28, 2022. So that's resolved one of two ways. Either in your proposed document to Mr. Morosky, you quash that writ, or I can adjourn today's hearing, maybe as a control date until we get the amended consent judgment, which resets the dates for the payments and the amounts and et cetera.
If you
tell
want
me
to-
how you wish to proceed.
If you'd like to amend, was it just set a control date, which, I think in this matter might be a decent idea. But in the meantime, in the judgment, Your Honor, we'll put an order in there that the order of eviction is hereby withdrawn. Was it as a resolution?
The motion needs to be withdrawn and part of the final order. that the writ
do
is
have
withdrawn
one
and,
question.
sure.
You can't
And-
withdraw an already executed, an already issued order. It's,
Oh.
it's-
Oh, I'm sorry, Your Honor. We would then, yeah, we'll put in the amended judgment, Your Honor, that the, order of eviction is quashed.
And that Ms. Lee's motion is withdrawn. Ms. Lee, you said you had a question?
Yes, and where do I make the payments at?
Mr. Morton?
You make them directly to the community as you have been.
Sorry, what was that?
You make them directly to the community as you have been.
Okay. Thank you.
So the timing. Mr. Morton, today is the 6th. Fingers crossed you could have it to Mr. Morosky by the 13th at the absolute latest. These are not dates that I'm putting in the register. I'm just making sure that those are realistic times.
Yeah, absolutely. Yeah, I mean, was it,
And
you know,
he'll have it signed and back to you before the 19th.
sounds good.
I'll adjourn today's hearing since the issues are actually still outstanding without an amended consent judgment. January 20th, 2023 at 10 a.m. back on Zoom with me and number one. I have other things scheduled that day, but that's just more so that you have this future date pending and maybe it'll help you stay on top of your paperwork versus falling into the no progress docket.
Understood, Your Honor.
Anything else, Mr. Morton?
No, Your Honor.
Anything else, Mr. Morosky?
No, Your Honor, thank you.
Thank you both very much. Have a good weekend.
Thank you very much, Your Honor.
Thank you, Your Honor.
I very much appreciate the court's patience with this.
And thank you.
No worries. Have a good
Ms.
day.
Lee, I'll be in touch with you as soon as I receive that document to go over it with you.
Okay, thank you.
You're welcome.
Mary Ann, this court stands adjourned. Thank